Imagine this. A police officer walks up to your car, reaches inside without your permission, pulls out a bag, and uses it to put you in prison for 10 years. Now imagine a court saying that evidence cannot be used. That arrest was illegal. That officer violated the Constitution, and you walk free. That is not fiction. That is real. That happened, and it changed the entire way police operate in America forever. Welcome back to this channel. Today, we are going inside the courtroom. We are going inside the most powerful, most debated, most important case laws in the history of American law enforcement. These are the decisions of the United States Supreme Court, the highest court in the land, that drew a clear line between what police can do and what they cannot do. And understanding these cases is not just for lawyers. It is not just for officers. Every single citizen living in this country needs to understand these cases because these cases protect you. So sit down, take notes, because what you are about to learn will change how you see every police interaction for the rest of your life. Let us start with the most famous name in all of police law, Miranda versus Arizona, 1966. You have heard the words. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. But do you know where those words came from? Do you know why they exist? Ernesto Miranda was a man arrested in Phoenix, Arizona in 1963. He was accused of kidnapping and sexual assault. The police took him into an interrogation room. They questioned him for 2 hours, and he confessed. The problem? Nobody told him he had the right to stay silent. Nobody told him he had the right to a lawyer. He did not know, and because he did not know, he talked. And what he said was used to convict him. The Supreme Court looked at this case and said, "This is wrong. This is a fundamental violation of the Fifth Amendment, which protects every American from being forced to testify against themselves, and the Sixth Amendment, which guarantees the right to legal counsel." The court ruled that before any custodial interrogation begins, meaning before police question someone who was under arrest or significantly detained, they must read that person their rights. They must be told they can stay silent. They must be told they can have a lawyer. If they cannot afford a lawyer, one will be provided. Now here's the deep part. Here's what most people miss. The Miranda warning only applies when two things are true at the same time. First, the person must be in custody. Second, there must be interrogation. If you are not under arrest and an officer just asks you a casual question on the street, Miranda does not apply. But the moment handcuffs go on, the moment your freedom is significantly restricted, everything changes. Every word must be preceded by those rights. The lesson for officers is simple and severe. Skip the Miranda warning and every confession you collect becomes useless in court. The lesson for citizens is equally powerful. You have the right to say nothing. Use it. 2 years after Miranda, the Supreme Court gave police a powerful tool and gave citizens a reason to understand exactly when that tool can be legally used. Terry versus Ohio, 1968. A veteran police detective named Martin McFadden was walking his beat in downtown Cleveland, Ohio. He noticed 2 men. John Terry was one of them, walking back and forth in front of a store, again and again. They would stop, look in the window, walk away, come back. McFadden, with 30 years of experience, believed they were planning a robbery. He approached them, identified himself as a police officer, and patted down the outside of their clothing. He felt the shape of a gun. He reached in and found 2 loaded revolvers. Terry's lawyers argued this was an illegal search, no warrant, no probable cause. McFadden had no specific proof of a crime. But the Supreme Court disagreed, and this is where the concept of reasonable suspicion was born. The court ruled that police do not need probable cause to briefly stop and pat down a person, but they do need specific, articulable facts that make a reasonable officer believe the person may be involved in criminal activity and may be armed and dangerous. It cannot be a feeling. It cannot be a guess. It must be facts you can explain out loud. Think about what this means in real life. If you are walking down the street and an officer stops you, they must be able to explain why. You were in a high-crime area alone is not enough. You ran when you saw us alone may not be enough. But a combination of factors, time of night, specific behavior, a nervous demeanor, bulge under clothing, can together form the picture of reasonable suspicion. The court called this a stop and frisk. It is limited. The pat-down can only search for weapons, not drugs, not contraband, not anything else. The moment an officer goes beyond that scope, the search becomes illegal. Terry versus Ohio drew a careful line, and officers are required to walk it precisely.
So why do we do this? Why does the human mind, which is extraordinarily powerful and capable of incredible things, consistently fail to act on warning signs? And the answer lies in three deeply rooted psychological forces that are working against us every single day. The first force is called optimism bias, which is the scientifically proven tendency of humans to believe that bad things are more likely to happen to other people than to themselves. We know that car accidents happen, but we believe we are better drivers than average. We know that businesses fail, but we believe our business is different. We know that relationships end, but we believe ours is stronger. And this optimism is not stupidity. It is actually a survival mechanism that keeps us moving forward through life rather than paralyzed by fear. But when it causes us to dismiss legitimate warning signs as things that only happen to other people, it becomes lethal. The second force is something psychologists call the cost of action versus the cost of inaction. When we see a warning sign and consider acting on it, our minds immediately calculate the price of action: the money, the time, the effort, the embarrassment, the disruption, the admission that something is wrong, and compare it against the price of inaction, which in that moment feels like zero because the disaster has not happened yet and may never happen. And our brains, which evolved to conserve energy and avoid unnecessary effort, reliably choose inaction when the threat is not immediately present. The third and most powerful force is something I want you to really sit with. It is the social pressure to not be the person who overreacts, the person who raises the alarm, the person who causes disruption by pointing out what everyone else is trying not to see. Because in almost every situation where warning signs were ignored, there was at least one person who saw them clearly and wanted to speak up, but looked around at the group, saw everyone else acting as though things were fine, and stayed silent. Because social belonging is one of the deepest human needs, and threatening it by being the person who says something is wrong here feels more dangerous in the moment than the abstract future disaster itself. So what do we actually do with this knowledge? How do we protect ourselves, our families, our organizations, our bodies from the silent disasters that are always preceded by warning signs we had been trained to ignore? And I want to give you something genuinely useful here, not just awareness, but action. The first thing is to create a personal rule that you take the first warning sign seriously, not the second, not the third, not after you've seen it 5 times. The first time your body feels something wrong, the first time a relationship feels cold, the first time a financial situation feels unstable, the first time an employee or colleague raises a concern, you treat that first signal as real. You investigate it. You do not wait for it to repeat itself, because the repetition of warning signs is not evidence that the problem is manageable. It is evidence that the problem is growing. The second thing is to build what I call a personal board of honest witnesses. These are 2 or 3 people in your life who have permission, who have actually been explicitly asked to tell you the truth when they see something you might be normalizing. Because one of the most reliable ways to overcome our own blind spots is to invite other eyes that are not subject to our own optimism bias and our own investment in things being okay. And the third thing, the most powerful thing, is to practice what I call scheduled honest auditing. Once every month, sit down alone with a journal and ask yourself one question with complete honesty. What warning sign am I currently ignoring? And you will be surprised every single time how quickly an answer comes, because somewhere in your mind you already know what it is. You are already aware of the thing you have been choosing not to look at directly, and giving yourself structured permission to look at it is often the only thing needed to begin acting on it. I want to leave you with this thought, and I want you to carry it with you because it has the power to genuinely save your life or the life of someone you love. The warning signs were always there before the accident, always, without a single exception in all of recorded human history, and the people who got hurt were almost never the people who did not see the signs. They were the people who saw them and decided that the discomfort of acting was greater than the danger of waiting, and by the time they knew they were wrong about that, it was too late to go back. You are watching this video right now, in this moment, which means you have something that no one gets to have after the disaster. You have time, you have awareness, and you have the opportunity to look at the quiet signals in your own life with honesty and courage before they become the catastrophe you will spend years trying to recover from. The warning signs are not your enemy. They are the most compassionate thing the universe offers you, a chance to change direction before you run out of road. Please do not wait for the accident to take them seriously. Please start today. If this video made you think, share it with someone who needs to hear it. Subscribe for more deep, honest conversations about the things that actually matter.
Before Miranda, before Terry, there was Mapp, and her case gave birth to one of the most powerful legal shields in American jurisprudence, the Exclusionary Rule. Cleveland, Ohio. Police received a tip that a bombing suspect was hiding in Mapp's house. 3 officers arrived at her door. She asked for a warrant. They said they had one. They did not. They forced their way in, searched her home, and found obscene materials. She was arrested and convicted, not for the bombing, but for possessing those materials. The case reached the Supreme Court in 1961, and the ruling was historic. The court said that any evidence collected through an illegal search, a search that violates the Fourth Amendment's protection against unreasonable searches and seizures, cannot be used in court, period. It does not matter how guilty you are. It does not matter what they found. If it was found illegally, it is thrown out. This is the exclusionary rule, and its purpose is profound. The court understood that if police could use illegally obtained evidence, they would have zero reason to follow the rules. The exclusionary rule is not a gift to criminals, it is a punishment for unconstitutional policing. It says, break the rules, lose your case. A simple modern example. An officer stops a car with no legal reason, no traffic violation, no reasonable suspicion, and searches the trunk and finds drugs. Under Mapp versus Ohio, those drugs cannot be used as evidence. The case gets dismissed. That is how seriously the law takes constitutional rights. Now we get to the case that every police officer in America must know by heart. Graham versus Garner, 1989. This is the cornerstone, the foundation of every use of force decision in law enforcement. DeThorne Graham was a diabetic man having a severe insulin reaction. His friend drove him to a convenience store for juice to stabilize his blood sugar. The line was too long. Graham ran out of the store and got back in the car. Officer Garner saw this and became suspicious. He stopped the car. During the stop, Graham was highly agitated because of his medical emergency. Officers restrained him, slammed him against the car, put him in handcuffs. By the time they confirmed he was not a criminal, he had a broken foot, a cut on his forehead, and bruises across his body. Graham sued, claiming excessive force, and the Supreme Court used this case to define exactly how use of force by police is evaluated. The court established the objective reasonableness standard. This means you do not judge an officer's actions by what they were thinking or feeling or intending. You judge them by what a reasonable officer would have done in the same situation with the same information in that exact moment.
The court identified 3 factors, known as the Graham factors, that must always be considered. First, how severe was the crime? Second, did the suspect resist arrest or try to flee? Third, did the suspect pose an immediate threat to the safety of officers or others? The court also said something powerful. Police decisions must be judged from the perspective of a reasonable officer on the scene, not from the calm, careful analysis of a judge sitting in a quiet courtroom after the fact. Officers make split-second decisions under extreme pressure. The law accounts for that. Graham versus Garner is the lens through which every use of force is examined in courts, in internal affairs investigations, in civil lawsuits. Every officer must understand it. Every citizen must understand it because it defines the legal boundary between necessary force and abuse of power. 4 years before Graham, the Supreme Court addressed the most serious use of force of all, deadly force, the right of a police officer to shoot a suspect fleeing. In Memphis, Tennessee, officers responded to a burglary call. When they arrived, they saw a teenager, Edward Garner, 15 years old, running across the backyard and climbing a fence to escape. He was unarmed. He posed no physical threat to the officers, but one officer shot him in the back of the head. Garner died. The Supreme Court ruled that this was unconstitutional. The Fourth Amendment prohibits police from using deadly force to stop a fleeing suspect unless that suspect poses a significant threat of death or serious physical injury to the officer or the public. Running away is not enough. Being a suspect is not enough. The threat must be real, imminent, and serious. This case fundamentally changed how police pursue suspects. An officer cannot simply shoot a person because they are running. There must be a genuine belief, based on real facts, that the person will cause death or great harm if they escape. Tennessee versus Garner saved countless lives and forced departments across the country to rewrite their pursuit policies from the ground up. Before we close, we must talk about vehicles, because most police encounters happen on roads, in cars, at traffic stops, and Carroll versus United States, decided all the way back in 1925, is the foundation of all vehicle search law. George Carroll was a bootlegger during Prohibition. Federal agents who had previously tried to buy illegal liquor from him recognized his car on the road one day. They stopped him, searched his car without a warrant, and found 68 bottles of illegal whiskey hidden inside the upholstery. Carroll argued the search was illegal, no warrant, no consent. The Supreme Court disagreed, and for a very logical reason. A car is not a house. A car can move. A car can disappear in the time it takes to get a warrant. Because of this mobility, the court ruled that police may search a vehicle without a warrant if they have probable cause to believe it contains contraband or evidence of a crime. This is the automobile exception to the Fourth Amendment's warrant requirement. It is why every single day, officers across America are legally able to search cars at traffic stops, but only if they have specific, articulable probable cause. A hunch is not probable cause, nervousness is not probable cause, but a smell of marijuana, a visible weapon, or a credible tip can all be probable cause. These cases, Miranda, Terry, Mapp, Graham, Garner, and Carroll, are not just pages in a law textbook. They are the architecture of the relationship between police power and human freedom. They were written in the blood of real people, real situations where something went wrong, so that the next generation would have rules, would have limits, would have accountability. Here's the truth most people never hear. The law does not exist to protect criminals. It exists to protect the innocent. It exists to protect you, the person who has done nothing wrong but still deserves dignity, fairness, and abuse of power. Every officer who puts on a badge swears to uphold the Constitution. These cases are the Constitution in action, and every citizen who lives under that Constitution deserves to know exactly what rights those words protect. Knowledge is not just power. In a police encounter, knowledge is protection. If this video taught you something today, share it, because the person who needs to know this might not know they need to know it yet. Stay informed, stay protected. I will see you in the next one.